So I'm going to start by reading what an injunction for protection in the county is, just very briefly, so that you kind of know like what you're about to hear and like what it is. So there's no question on that. What's this? They've changed stuff. Good Lord. Barely learned like how to use the other one before they change it to something different. So can you guys see that? Okay. All right. Injunctions for protection. What is an injunction? You have the right to file a petition to ask the court to issue an injunction to protect you against violence. The injunction process is a civil court process and is not a part of the criminal court proceeding. An injunction is different than a criminal no-contact order. An injunction is a court order against another person who has been physically violent with you or has placed you in fear of physical violence. The purpose is to require him or her to stay away from your home, your car, your place of employment, and other places the court finds necessary. Also, injunctions can order the other person not to contact you by phone, in writing, by email, or in person. Injunctions can include other relief that the court feels is appropriate. And there are 4 types of injunctions. So you have a domestic violence one, a sexual violence one, a dating violence, and repeat violence. So what happens? 3 things can happen after you file the petition. So the petition was filed. It will be read in this audio towards the end. The judge can enter a temporary injunction for protection. The judge can enter an order setting hearing only. This means that there is no injunction in effect until the hearing. The other person will be served with a copy. And number 2 is what occurred in this situation, I do believe. And then the judge can deny the petition and should give reasons in writing why the petition was denied. The other person will not be served with a copy. You can file a supplemental petition and add on any other information that you think you may have left out the first time, or that may make a difference in the decision. So what Greeno is saying that he has a order of protection against me for covering his true crime case, and it was denied. So I've showed that over and over again. He's added on some kind of green paper form and no claw. I don't know what he's talking about, but I've called them. They said that's not true. You can believe me or you cannot believe me at this point. Like, believing that guy is just like, you might as well believe that. Like, it's like believing in something that is just absolutely ludicrous, you know, like to believe anything that he says thus far, like based on past behavior, like, and he's already out just lying about, you know. So, you know, how do you properly defend yourself against someone like that? And you all saw the thumbnail and what it said. So basically, you know, he's saying that there is no charges, and he is correct about that. There is no criminal charge. I just read you what this is. Now, well, let's read what happens if the injunction is violated. If you're in immediate danger, call 911. You should also contact the clerk of court to file an affidavit describing the violence. Victims should carry the protection order with them at all times. An injunction for protection is a civil court order. However, a respondent who does not abide by all of the conditions of the protection order may face criminal charges or contempt of court.
I gave you an opportunity to admit any physical evidence in rebuttal. I have enough information to rule, however, at this time, and I don't believe that that is necessary. Based upon the sworn testimony offered in open court before this court, I find the petitioner has met her burden of proof. The court will issue an injunction for protection against stalking violence. This will be in place for a period of 5 years unless extended by the court or modified prior to that time. Either party has the opportunity to file a proper motion and have a hearing take place that will address whether it should be extended past the 5-year period, modified prior to the 5-year period, or dissolved altogether. So at this time, the injunction for protection against stalking violence is issued. The court finds that the statutory criteria has been met, and the evidentiary burden to prove that has also been met. With that in mind, the court issues the following injunction. I will read it into the record. Final judgment of injunction for protection against stalking violence after notice is issued. I'll find he was properly noticed, he being the respondent. The injunction terms are as follows. This would be in full force and effect until 2027, December 6, 2027, unless modified by either party by order of this court. Modified by order of this court at the request and proper motion and notice of either party. Prohibited acts, the respondent will not commit or cause any other person to commit any acts of stalking against the petitioner, including stalking, cyber stalking, aggravated stalking, or any other criminal offense resulting in physical injury or death. Respondent shall not commit any other violation of the injunction through an intentional unlawful threat. The respondent shall have no contact with petitioner unless otherwise provided. There'll be no exceptions. The respondent shall not go to nor within 500 feet of the petitioner's confidential address or any residence that she may live at, and may not go to nor within 500 feet of petitioner's employment. I can't tell if that was supposed to be confidential or not, so if that is an address you'd like to have included, please read that into the record at this time. All right. May not go to nor within 100 feet of the children's school. Do you wish to place that into the record to be added, or would you like to leave that confidential?
I don't know if it's necessary, but I can leave
It
it.
remains.
I'm sorry.
I can leave it confidential.
Okay. Because an injunction has been entered in the state of Florida, the respondent is not legally permitted to own or possess any firearms or ammunition. Therefore, that will become the order of the court. And that will complete the order that this court is issuing. I will tell each of you, if there's some dispute about personal property, that is for a civil courtroom. Everything I've heard here today is anything but civil. If you have things that you'd like to get back that you can't agree to exchange, that goes through the civil division of the court that has proper jurisdiction. Any communication about any of these issues directly to the petitioner will be considered a violation. That is the order of the court. Copies will be...
There you go. You know, when you go around telling lies and the truth can be shown, you know, like everyone's been saying in the chat, there's your receipts.